Morning, ladies and gentlemen. We will have a webinar today in which we will talk. We'll speak in English. So I'm confident that our viewers are able to understand the language. We have very good panelists today. We are very proud to have them and very happy that they accepted our invitation and are having time to speak with us. Today we'll have Mr. Tilman Kuhn. Mr. Tilman is a lawyer based in Germany. He works for a very good law firm, White Case, and he is very accustomed to the themes that we are dealing today. We will have Ms. Anne O'Brien, who works for a law firm, BakerHostetler. She's an American, former federal prosecutors from the DOJ Criminal Division. We will have Carlos Ragazzo, former General-Superintendent of CADE and Professor of FGV Law, and Mrs. Paula Azevedo. She is a Commissioner at CADE, and all of them are very good with the team that we will deal today. It's price gouging. It's a team that theme that in antitrust, it's always talked, but unfortunately not that much discussed in deep. We are trying today to have a deep conversation about it, especially because since the COVID crisis, it's one of the major themes in antitrust. We can see several complaints about prices being too high with certain things in a time of crisis, and in which you can see that the behavior of economic actors it's of very much concern for everybody. I will have alongside me moderating the event Eduardo Frade, which is a former General Superintendent of CADE 2, and it's a partner at VMCA Law. Eduardo, would you mind to field some words for our viewers, please?
Sure. Thank you, Victor. Since there's no one to present you, I'll present Victor as well. So Victor is an attorney with Mudrovich Advogados in Brazil, and he is the former general attorney of CADE. So we've worked together, me, Victor, and Ragazzo. Thank you all very much. Thanks to our panelists for joining. This should be a very interesting discussion, a theme that is being discussed deeply in Brazil, but also worldwide. Hence, us having here a representative from the law bar from Europe and also from the US. As Victor was saying, since the sanitary crisis started, we have had significant price increases in several goods. Of course, the main ones tend to be the ones related to the health sector, but we've also seen price increases in other goods. Here in Brazil, in gas prices, for instance, in some countries, even food and so on. It is indeed a scenario in which everything converges towards price increases. So to talk about health-related products, for instance, we have an unprecedented demand spike for certain goods, but at the same time, we have output decreases precisely due to lockdowns and restrictions and so on. So just to get one example, and I'm quoting some of these numbers from a paper from Frederick Geny of OECD. Before this all started, the theoretical Chinese production capacity for masks, face masks, was estimated to be around 20 million masks per day. Due to the pandemic and lockdowns in Wuhan and other cities, China was only producing 15 million masks a day, so less than it could produce beforehand. And China was the biggest exporter in the world. But after the pandemic and the problems in China, the demand in China itself spiked to 50 to 60 million masks a day. So much, much higher than the production of China itself. So not only was China not able to export masks anymore, it had to import masks from other countries. Several other countries then started to stop their exports of masks. And you can see the huge problem we have with a demand spike and an output decrease. This, of course, has an effect on price increases. Not only that, but we've had significant increases in related costs as well. So for instance, several companies that sell masks and other goods worldwide are asking for down payments to be made beforehand. Masks that used to be shipped are now being sent by air transportation because the situation is urgent. Of course, this is much more expensive. There are logistic difficulties due to the restrictions. We have less flights. We have extra risks. For instance, we have products sometimes being confiscated during a flight connection in a certain country or another country. We have, as I mentioned here, products being confiscated when they enter the country itself because the local sanitary authority is in need of those goods. So that puts a lot of pressure on price increases as well. So there seems to be a general explanation on why prices are increasing so much. And in several cases, we are seeing really, really big price spikes. We're not talking about 10%, 20%, we're talking to 5,000% in certain cases. Of course, this is serious, this is very problematic. What we're going to discuss here today is whether this is illegal and how authorities worldwide should deal with this. The fact is, after these spikes, antitrust authorities, consumer authorities all over the world started releasing statements and opening price gouging investigations. This includes authorities in Europe, this includes authorities in the US, this includes Brazil. Not only this, probably due to this general feeling that companies might be pursued, we have companies such as Amazon and eBay that have been, for instance, barring advertisers that have been unreasonably raising their prices. So some companies are taking the role of the regulator, and they themselves have been barring companies that have been raising their prices. Of course, this raises the question of how is Amazon looking into this, and is this actually making our output decrease crisis even worse instead of making it better? These are some of the questions. To give you a general scene of what's going on in Brazil, before we talk about Europe and the US. So in Brazil, we have both federal and local consumer protection authorities that have been inquiring companies about price increases. So we have not only the antitrust authority, but consumer authorities in local capacities that have been looking into this, price gouging and price abuse and so on. We have sanitary local authorities that sometimes have been confiscating goods. So they are in need of face masks in that certain city. They'll go to the warehouse of a certain company and they'll just apprehend goods. And they'll pay the price of the masks before the pandemic. The thing is that masks were not bought by the same price. The costs were much higher. So this is, of course, this raises an issue. We have congressmen proposing to freeze prices of certain goods. And of course, the antitrust authority, CADE, has started a preliminary inquiry asking for providers of health goods, in particular, to inform their prices in what seems to be a price gouging investigation. So CADE has given the basis for this investigation. We don't know what the standard is going to be, but CADE has given the message that it's looking into price gouging and it's asking for a lot of data to be analyzed. At the same time, we've had interesting responses by CADE itself. So CADE's president and CADE's Department of Economics have openly adopted a position against what would be precipitated price cap regulations and warning for the dangers of price cap regulations due to the fact that this could generate even a worse effect on output itself. CADE's General-Superintendent, who is the person now in charge of this investigation, has also given public statements in the sense that price increases on its own, or even margin increases on its own, should not be considered a violation. But what should be considered violations are what he called opportunistic behaviors. This, of course, these are oral statements. We don't have a written response by CADE yet. The fact is, it's still very much unclear to companies, and in my view, to authorities themselves, what this means exactly and what are the standards that will be adopted. The fact is, we have, I personally haven't seen one single authority or a scholar anywhere that has been able to answer this puzzle. With a few exceptions, especially in Europe, in my view, price gouging is something that had been virtually none. We hadn't heard about a serious price gouging investigation anywhere. In Brazil, certainly not. And now all of a sudden, everyone is pursuing it, and no one is able to answer. First, what exactly is price gouging? What are the standards here? What standards should be adopted? Why should this be overseen by antitrust authorities? Are we talking about price regulations? What are the remedies that should be applied? Still a lot of open questions. Even brilliant professors like Frédéric Geny and Massimo Motta have recently manifested that price gouging may be an issue that perhaps should be looked by the state. But neither of them, that I have seen at least, was able to answer these questions in practice. The standards, what is price gouging? How should we deal with this? So this is a bit of the questions that I have here today. I'd love to hear about what our panelists have to say. We'll start with Tilman Kuhn. Tilman, thanks for being here. And have the European authorities answered these questions? How is Europe dealing with this? Do you have the answer for these questions? I'd love to hear.
So let me see if I can share my screen here. Thank you, Eduardo, and thank you, Victor, and everybody else for allowing me to speak. As you know, I'm very happy to engage with the Brazilian community, and Eduardo and I crossed swords a couple of times when he was in his old role, and now I have the enjoyment and pleasure to work with him on a number of other matters. I think that the introduction that you just provided was absolutely perfect. It's precisely the problem that exists with excessive pricing, and really price gouging is another form of excessive pricing everywhere, and has been existing with that topic for decades. There's been a bit of a thinking around, I know it when I see it. There's an unjustified significant price increase, and that somehow looks like excessive pricing. But what exactly is the threshold? That is really the big question, and I don't think there's a good answer. But let's go through it, and I'll get to it as concretely as I can. I think that the topic has really come up again in this crisis, but we've seen it in other scenarios before. Of course, there's been previous crises. So in the oil crisis in the 70s, there's been several investigations and actually decisions by, for example, the European Competition Authority, the European Commission, on unjustified price spikes for oil. We've seen it quite a bit in the pharma industry, where around the time that a pharmaceutical product goes off patent, all of a sudden the price is increased. And the question then arises whether there's any justification for it. Again, the smell test, why is there all of a sudden an increase where the patent expires? That doesn't seem to be sound. And then, of course, you have discussions now in a more creative way around data collection and data usage, and whether that is something akin to excessive pricing, to be excessively collecting user data. We see, more specifically to the current situation, statements from the European competition authorities. Both the European Commission itself has made statements. I have a statement from Commissioner Vestager here. We have a statement from the European Competition Network, which is the network of national competition authority within the EU, including the European Commission as the pan-EU competition authority, that they will very closely monitor this, that they encourage people like you said, Eduardo, people like Amazon or others to use all of the tools that they have to try to prevent that. And it's primarily artificial intelligence based. and then also to think about, manufacturers or other suppliers, think about their possible strategy to prevent this, such as imposing maximum prices, which usually is viewed as not being an antitrust offense. So maximum prices for resale may be another tool to deal with it. All of these things have been discussed. I think the core of the problem really is that there are a couple of surprises in this space, and it's really a patchwork of regulations and considerations that makes it so difficult to grasp, right? So first, I think this topic again is not new. We've seen it in other industries, in other circumstances, but nobody is really having a firm grasp on it, and we'll be discussing this for a longer period. That's why I think it's an excellent topic for this webinar. Second, there are a couple of angles, and Eduardo, you've alluded to a number of them. So there's the antitrust angle, which I'm sure will be the focus of this webinar, but there's also other angles, such as consumer protection law. A number of competition authorities have both antitrust and consumer protection enforcement powers. Others have some competence to discuss consumer protection, but not really through enforcement powers, only through things like sector inquiries. And then there are some special laws that are being passed right now. For example, in France, there's been a special law imposing price caps on sanitary gels that may be the tool to apply to prevent price gouging. The other thing that I think we will see is an attempt to make use of interim measures, because really you want to intervene quickly. People need face masks now, and it doesn't help them if 2 years from now, at the end of an antitrust investigation, there's a price decrease. So I think we'll see some more of that, and that means quick action is needed. I think an important reminder for people who are making their prices right now and maybe considering to benefit from the crisis is that there are certainly national laws in the EU and elsewhere that provide for liability of the individual managers who have pricing power, not only the companies that are selling the products or services. And these can even be criminal, including jail time. So I think it's very important for people to be aware of this. And then last but not least, and that's maybe something that not too many people have on their radar screen, price gauging may be unintentional because we do have many industries with algorithm-based pricing. And there's a very good example. I'll talk about that in a little bit in Germany, where Lufthansa, the biggest airline here in Germany, was facing an investigation for excessive pricing after one of its competitors went bankrupt, and all of a sudden it became the monopolist on certain routes. The starting point from the antitrust perspective is really that typically under antitrust law, price gauging can only be acted against if the company that is engaging in such seemingly unlawful price increases is dominant. And that's a pretty high threshold. So finding a dominant position requires first to define the relevant market. And there, of course, the agencies have some wiggle room to potentially define the market relatively narrowly from the perspective of certain complainants to more easily reach the finding of a dominant position. There may be concepts such as temporary dominance or immediate dependence on certain suppliers, and that's precisely what we found in the oil crisis, in the so-called ABG oil case, where the Commission found that a certain group of purchasers was dependent on a number of suppliers in that crisis period. Now, outside the crisis, they would not have been dominant, but during the crisis, they clearly were. And it wasn't only one company, it was several companies that were dominant, and just one of them not playing by the normal rules of fair product allocation and fair pricing may be abusing its position. Second or third, it could be a collective dominance concept, so where you act in an oligopoly, maybe it's enough to say there's a collective dominant position and one company is abusing it by excessive pricing. And then the last but not least thing, and I know the other panelists may not like to hear it given their agency background, but sometimes we do have the impression the agencies are somehow re-engineering the dominant position based on the abusive behavior that they'd like to punish. So the mere fact that the price has been increased so massively may indicate that the company who's done it is dominant because it apparently does have unchecked market power. Otherwise, it couldn't have increased the price. And that's precisely the problem that we've always had with the concept of excessive pricing. from an EU perspective, it's crystal clear that it's not unlawful to be dominant, right? The dominant position as such is not a problem. It's only a problem if you abuse that position. Now, if you define dominance, you would typically say an undertaking is in a dominant position if it has the ability to act independently of competitors and consumers. It has some unchecked market power, unchecked freedom to act, such as, in terms of pricing. Nobody else constrains it enough on pricing. But then, how can be high pricing as such an abuse? If that's more or less part of the definition of dominance, that you can charge whatever prices you like, how can that be at the same time an abuse? So that's really the problem that nobody has been able to solve, apart from the second problem, which is what is an appropriate price? What is an appropriate profit margin? And to what extent is it demand and supply and the economic value of a product or service that determines the price versus some unlawful intentional profiteering? Striking that balance is really difficult. Based on the case law in Europe, you see that it's still even there, although we do have a few cases, even court cases, a relatively vague concept and very hard to nail down in practice. We have the United Brands jurisprudence from the 1970s that says a price of a dominant company may be excessive compared to the costs incurred or somehow unfair in itself or when compared to other products. And we've seen some recent case law here with copyright societies where you have typically national monopolies, and you could compare the prices that one national monopoly charges with the prices that the other national monopoly charges in a neighboring country. Of course, both prices may be super competitive, so maybe that doesn't help so much, but at least the court opined a little bit here and said if you want to look at comparable prices in other countries, this comparison needs to be based on some objective, appropriate, and verifiable criteria. And also, it's not just any higher price is as such unlawful. It really needs to be significantly and persistently above the competitive level. Very well understandable as a general concept, very difficult to apply for any specific pricing. What I have found to be a quite unknown case, but I think it's very helpful to understand the issue a bit better, is a case that the European Commission decided in 2004. It was about ferry services and other types of services at a harbor. And there it said, the difficulty with finding a price to be excessive is not just a comparison with other prices or a comparison with the cost. Who will opine on what an appropriate profit margin is? The problem is that there is a different economic value that a customer may associate with a product or a service, and that may be something very subjective. And really, that makes it difficult to nail down, is this now far beyond the economic value, or is it a fair price for the economic value? In Europe, you have the additional complexity that, as I've hopefully explained, EU law has relatively high standards, a relatively high bar to find pricing to be excessive. National law may be stricter, right? So while we have a full harmonization for horizontal and vertical agreements, so everything that is at least bilateral or multilateral conduct, for unilateral conduct, national law may be stricter. And we do have lower thresholds for finding a unilateral behavior unlawful in a number of countries. We do have a number of countries that have economic dependency types of laws, especially applying to your food retail, supermarkets, and so on, where certain suppliers may be dependent on the big supermarket chains as buyers. We have a concept called relative dominance in Germany, where it's not about your absolute market share and the gap that you have to the next biggest competitor, but it's more around the relativity between you and the customer, or between you and the other competitors. There's consumer protection laws, of course, that can tackle this issue, and as I mentioned, some special legislation. I think the two most interesting cases of the last couple of years prior to the crisis are probably the Pfizer-Flynn case in the UK. I'm still talking about the UK as a member of the EU, although technically it isn't anymore, and then the German Lufthansa ticket pricing case. So in Pfizer-Flynn, there was an overnight increase of a price of a drug by 2,600%. which the CMA found to be an abuse of a dominant position, but it lost on appeal because it had not considered sufficiently the economic value that the patients would place on that drug. In other words, if patients are prepared to pay that, if they think it's still, it's expensive, but it's still somehow fair, or I will do it, that needs to be taken into account in the question of, are we really talking about something that is excessive and hence unlawful or not? The Lufthansa case, again, is also illustrative. So all of a sudden, the only competitor on certain flight routes goes bankrupt. So all of a sudden, overnight, you're becoming the monopolist on this route. And the prices actually went up by 25 to 30% for a number of months right after the Air Berlin bankruptcy. But then a month or two later, another airline took over the slots and entered the market, and then the prices went down again. Here the question was, at least temporarily, had Lufthansa abused its dominant position on these monopoly routes? And the Federal Cartel Office did an investigation and came to the conclusion that there was no abuse of dominance here, simply because, first demand and supply operate in a certain way, and if all of a sudden there's a shortage, or all of a sudden there's much higher demand than supply, then it's normal, even in competitive markets, that prices go up. Second, it was short-lived, and you saw that there were no major entry barriers here, so through new entry, the pricing was constrained again. What's perhaps most interesting is that Lufthansa had tried a somewhat creative defense here and said, I haven't even increased the prices, it was my algorithm. That, of course, didn't fly as a defense. It was clear that Lufthansa itself set the parameters for the algorithm and for the pricing and bears responsibility for it. It does show, though, that price increases may be unintentional, and sometimes there's even a bug in the software and so on. And so people that are setting prices through artificial intelligence really need to be very attentive to the issue. I've briefly mentioned the Facebook case, and maybe I'll get back to that after we finish this topic. Just as a quick overview to answer Eduardo's question, what are we seeing in terms of cases now in this crisis? We do see enforcement primarily by the national authorities, the European Commission picking up short-term price increases in individual countries, and prices may be differing from country to country, also a bit depending on the shortage in an individual country and the status of the lockdown. That's not really something that the European Commission will spend a lot of time on. So they leave it largely to the national authorities. And then you will see here in my quick overview a real mix between actions by antitrust authorities, at least by way of establishing some sort of a task force and starting inquiries, like you've mentioned for CADE. You see consumer protection authorities in certain countries that are acting and are even issuing interim measures, which is something very helpful in this situation, that they can act so quickly. And you see that, for example, in Germany and also in Italy. And you see some countries that are setting up special laws, such as the French government on the sanitary gels. Turkey is maybe the most interesting investigation that you're currently seeing, because there I think they have a number of blue chip corporates that are looking into, and it will be very interesting to see how they allocate responsibility between a manufacturer and the supermarkets and so on. Long story short, I think we do see investigations. We do not see yet any clear guidance as to what level of price increase is excessive, and at what with what criteria you would look at that. And I think it all comes back to the original problem that we've had for many decades with excessive pricing cases and this dominance paradox. Who is it to pronounce an opinion on? There is a price that does exceed the economic value of the product by so much that it's an abuse of a dominant position. Again, I think we need to take all of the learnings also from this crisis and see how we apply them for when the crisis is over. We do see, as I mentioned, quite a number of cases in the pharmaceutical industry that may be also informed by what we see in the crisis and the agency practice now. We do see new theories that are akin to excessive pricing, such as excessive data collection. In the German Facebook case, the claim by the FCO was Facebook was abusing its dominant position in social networks by collecting more data than it would be telling consumers it is collecting, and somehow unfairly doing that and infringing the data privacy laws, more or less automatically that would be an antitrust violation. European Commission has publicly stated they don't believe that's the right way of looking at it. And in the first instance in the court of Düsseldorf, the Bundeskartellamt has lost the case, but we'll see what the main proceedings bring. And then maybe the last point, as we're moving again more into digitalized industries, I do think we will also see this topic come back when we see more individualized pricing, right? So when you and I go to the supermarket, we may pay a different price for the same product than somebody else with a different budget and a different purchasing history. These AI solutions are being worked on, they are coming, that certain stores will be able, based on your mobile phone or whatever data they have with you, to figure out what your budget is and give you a different price on the shelf than somebody else who's standing next to you. And also there we will have that discussion. Is this all of a sudden an unfair price because I can afford more or less than the guy next to me? That I think is where we will see the debating. So maybe that as an introduction from Europe.
Thank you, Tilman. This was really very, very good. I think we got to see what's going on in Europe. You've raised several of the questions that I have myself, several of them still unanswered, but I think you were able to give us a good view of how this is being seen and what types of measures European authorities have been taking. Different measures, right? We have from price gouging investigations with different angles, from an incentive to companies themselves to try to control resale pricing, to regulation initiatives through legislation. So I have several questions here. I'm not going to pose them now because I think we should give the opportunity for our other panelists to talk about this a bit and maybe answer these questions. I'm going to turn this to Anne. So Anne, I've been seeing that your firm, BakerHostetler, and yourself, you've been doing a lot on covering the legal aspects of this whole crisis and antitrust in particular. And I've seen that you have been writing and speaking about price gouging and what has been going on in the US. It's a very interesting angle because you seem to try to explain to your clients what to do, right? How to behave in such a scenario, which is something that our clients here have been asking as well. So it'd be great if you could give us an overview of how the US has been dealing with this matter, what sort of advices you've been giving to clients.
Yeah, thank you. Thank you so much for inviting me. And it's been a pleasure to join many of you who, as panelists, who I've worked with as an enforcer before when I was at the Department of Justice Antitrust Division. And now some of you are colleagues again in private practice. So thank you for the invitation. And thank you to everybody listening for your valuable time, because I know that it's a difficult time. So logging on to a webinar. I have to say this is very hot topic, price gouging. I do prefer how Eduardo and Victor, you pronounce gouging better than any other moderators on my panels about price gouging. So the Brazilian flair to gouging is really the preferred international pronunciation, I believe. So thank you for that. Before we jump into what's happening now with price gouging in the US, let me just give you some context for price gouging. Throughout my 20 years as an enforcer, we usually saw price gouging concerns in the US previously after natural disasters like hurricanes. And usually the concerns were about spiking gas prices or water that people needed after a hurricane upset the supply of water, or building supplies to fix people's houses. And there's no at the federal US level, there's no price gouging specific law. And so price gouging in the past, when we saw these disasters, was primarily a state issue. And I sat on price gouging task forces in the US as a DOJ representative. And really my role was, if anyone sees horizontal collusion, price fixing, come talk to me. If not, you're concerned about the price you're paying for these things, it's a state issue. So I had the luxury as a federal enforcer of that being my role, and seeing some of these price gouging issues play out at the state level. And I watched them with interest, but the issues up until now, up until COVID, were really state issues in the US. When I've been putting together these presentations, I think I've done 4 other webinars on price gouging, a number of articles. I tried to think about what is the definition of price gouging. And I looked up all these definitions, and it's not really defined in the statutes. But I think generally, and it's very similar to what was described as, the European statement, is that price gouging is when a seller increases prices to an exorbitant amount to capitalize on an emergency. But really, that's just the common understanding of it. There's this idea to capture profiteers. But in my experience, figuring out, what a profiteer is, what is a gouge, is much more difficult. And these price gouging laws in the US are really much more nuanced. And I'm advising clients every day who are facing this everyday changing web of state and federal laws that they're trying to abide by, particularly as, national level retailers. So price gouging is really certainly of great public concern in the US, as I'm hearing that it is around the world. And it's, no one wants to pay super high prices for things that they desperately need in a crisis. But I've always viewed price gouging as really tricky from a competitive perspective, a competition and antitrust perspective. I personally have not viewed it as an antitrust issue in the past, but more of a consumer protection issue. And when I was at the DOJ and we didn't handle consumer protection, then it was easy for me to say, this is a consumer protection issue. And the antitrust nerd in me, I'm not an economist like some of you, but has to point out that under antitrust and free market principles, businesses are typically allowed broad freedom over the prices they charge for their products. And working with clients, it's really hard to discuss that with them because they're used to being able to set their prices. And they say, someone wants to pay this price for this mask. How is it possible I can't charge that? And I say, absolutely true. But we are not in the regular world right now. We are in the COVID world. We are in a state of emergency in every single state in the United States, and the president's declared a state of emergency. So for right now, different rules apply. One additional concern that I've seen in advising clients is we're back. So I was just getting geared up. So it was like a cliffhanger because I was telling you how it was in the US before COVID. So let's jump to now. And it was talking about how some businesses, there's a concern that some of these price gouging laws may actually disincentivize or stop people from entering into markets for providing things like PPE, protective wear, masks. And I've even seen businesses in adjacent industries. So maybe they have the ability to import goods, or they're making uniforms in the medical industry, and they have the ability to get masks, which are vitally needed in certain parts of the US, as I'm sure they are around the world. But then when they discuss these price gouging laws and all the risks that Eduardo described about product being seized if they're viewed as price gouging, they just don't enter that market. They don't bring the masks to where they need. So that is like a real life thing that I'm seeing in the US that is concerning in some situations, that those who could be bringing more product that's vitally needed to markets are not, because they're concerned and they don't want to be an inadvertent price gouger or have their brand harmed by being viewed as a profiteer. So as I said in the US before, there was never a federal price gouging law on the books, but a few things came together in the last month and a half since March 23rd in the US, so that now, at least for temporarily, there is a federal price gouging law. And the things that came together were that President Trump did an executive order that invoked the Defense Production Act. It's very rarely invoked, but in a crisis like this, he invoked it, and that triggered some price gouging laws. Really, it's called hoarding and price gouging. And now it makes it a crime, a misdemeanor crime for individuals and companies to accumulate these items in excess of reasonable needs, that's hoarding, or for the purpose of selling them in excess of prevailing market prices. And we'll discuss what that means, but that's the price gouging part. And these are misdemeanor crimes punishable by up to a year in jail and $10,000 fine per occurrence, which I wonder if that means what an occurrence is. Is that every sale or just the group of sales? But so that is now being enforced by the DOJ. So where I used to work, when we used to not have a law that was enforceable on a federal price gouging level, now there is one, at least temporarily, until this state of emergency goes away. So that then, through a series of other steps, there had to be a list of scarce products. What are covered? And really, it's not surprising. The products that are covered are PPE, the protective wear, including masks, ventilators, some drugs thought to fight COVID, but not things like food, not things like toilet paper that people see in demand. Those things aren't covered. So that's a little different from past crises. And also that's something that I'm finding myself explaining to clients that are concerned about violating these federal laws, is that this only covers a certain list of products, which are mostly healthcare related products. And, you know, the standard here at the federal statute, which we've never seen before, is prevailing market prices. So what does that mean? Just as described by others on the panel, you know, as it's not really fleshed out yet. And as a former prosecutor, I wonder how the elements of that misdemeanor offense will be proven to a jury beyond a reasonable doubt. And that remains to be seen. So we're watching each and every case very closely. And there's a task force on hoarding and price gouging that's been put together out of New Jersey with the Antitrust Division, my former colleagues. They're slated to help. And there's a CNN report. It's an unnamed DOJ official, so you know, that is who's cited, but it says that the U.S. Justice Department has more than 150 open price gouging and hoarding investigations. So that's a lot. I mean, the Antitrust Division had less than that per year of all cartel conduct. So that's a large number. And so we're watching these every day. So when I'm trying to advise clients on what is excessive pricing that the federal government in the US may deem gouging, I have nothing to go on because there's no history of this. There's no litigated cases. So every day I set alerts and I look at if there's new cases. And so far we've just had 2 and one other arrest that was related. And I'm a bit surprised at what the facts of the 2 cases are. They're both in the New York area. That's where this task force is run out of. And they've been in the last few weeks. April 24th was the first one under this Defense Production Act. And there, a person in Long Island was charged with hoarding and price gouging. And I read very closely the complaint for data points to use when advising clients. And I was surprised that the prices the complaint cited as excessive included N95 masks for prices of $3.99 and $4.99. So that's less than 100% increase from the $2.50 that the person had paid. So I was expecting to see thousands of percentages increase, and some of the state cases are showing that. That was not high to me, and I have worked with clients and know that hospitals and others are more than willing, and many people sitting in their homes are more than willing to pay $5 per mask if they're able to do that. So that was a bit surprising. Now, I do think that person was warned in the past that they were looking at those sales. There was another criminal hoarding and price gouging case filed April 28th, which was actually against an attorney who was working with the client also who was charged. And for conspiracy to violate the Defense Production Act. There was a lot going on there. There was also some fraud. They were wrapping up boxes that were empty and selling them, which is not an antitrust competition or price gouging issue. It's just lying and fraud. So that was also going on. But I read this complaint very carefully to see what was the excessive pricing. And there is a statement that the agent that was swearing in the complaint said that masks were sold in excess of prevailing market prices, including selling KN95 masks for $418, and which is a 300 to 400% markup over previous prices. So they were less focused in the second case on the difference between what that person paid and what they sold them for of the previous market prices. There was another arrest made where the person wasn't charged with price gouging. They actually were arrested during when they went to do a search because the person spit on them and said, on the agents, and said, I have COVID. So that was deemed an assault. And they lied about selling the masks. But the investigation was clearly about selling masks. And they say very carefully in the complaint, without charging them, that the markup there was 700%. From what the person paid, which seemed more, 700% to me would be less shocking than a less than 100% increase. Now, there is numerous US laws proposed right now, at the federal level in Congress, that would prohibit price gouging. They all have the same problem we're talking about. What is the gouge? What is the standard? We've seen laws like this proposed in the past and none of them passed. So the states are also very active. In fact, last night I was emailing with a client who received 5 letters yesterday, a retailer and a platform that received 5 letters, cease and desist letters from states saying, 5 different states in one day saying you're selling this product at an excessive price. So that client, of course, is asking me the standard in each of these states. And I'm keeping a chart and I'm looking at this every day because there are new laws, there are new states of emergency. But they're doing this every day. And the state laws, there are 38 state laws and the District of Columbia in the US, and they all have different standards. So it's very hard to advise clients. And so, you know, when I was a prosecutor and I'm looking at price fixing, I don't think I ever met an inadvertent price fixer. We always had to prove that beyond a reasonable doubt. But when you're talking about price gouging, I do, I'm working with clients who are not trying to gouge. They have increased costs. There are a lot of increased costs today. We could go on for a long time about how transportation, labor, they have to clean so much more in retail locations that are even allowed to be open. The costs of these products are going up. So it's understandable from a supply and demand aspect and a cost aspect that their retail prices will go up. But many of these states put a cap on it. California has, and New Jersey have a 10%. You can't increase more than 10% from the price either right before or what some of them go back 30 days before the emergency was stated. So we have to look at the before and after pricing, which is difficult. Hawaii, for instance, just had a law. It just says you can't raise prices on essential products at all. So a client called me that there was a mistake in pricing. They were pricing just like the scanner was pricing at the wrong one. Can I put it back to the right price, or is that increasing it? I mean, then that company's really trying to do the right thing here. So basically what I'm doing, to cut to what Eduardo discussed, what do you do then? How am I advising clients, companies that really are trying to price things without running afoul of these price gouging laws in the US? Nearly all of the US state laws, the federal one currently in place doesn't have this, although I think they would take it into account, but the state laws have some sort of exception where the seller can prove that price increases was proportionate to the increase in input costs. But the interesting thing is that's an exception or a defense, and the burden is on the seller to provide that. So when my client gets these letters from states, they often have that data to show that actually it was not an increase in their profits. They weren't profiteering, it was an increase in costs, but the burden is on them to document that. So when I'm working with clients, I'm telling them all the time to keep documenting the prices, because if you can say the prices are, the profit margin is the exact same as it was pre-COVID, that is very helpful. And I'm advising them, that the safest route is to focus on the costs for that product or service and then build in their typical profit. That's more difficult for companies that might be new getting into an industry like selling masks or PPE and don't have a pricing history. But if they do, I'm encouraging them to build in their typical profit margins to reach their prices. But when doing that, you have to, it's a difficult conversation to have because it may be well below what someone is willing to pay for that. And they say, I have people offering me this amount for it. So how can they be offering me, even hospitals offering me this amount for a product, and that can be in violation of the law if that's what someone wants to pay? But in this COVID world that we're in, where these laws are invoked now, that is the situation. So often they're being called upon. And also companies are worried about the reputational harm, you know, so even if they could have someone pay that price, do they want to be characterized as a profiteer? So very interesting line of cases the last couple of few weeks here is that, for instance, masks, you know, 3M is a huge branded seller of masks and other PPE. They decided as a business decision to keep their prices static for those masks. So if people had contracts in place or even new contracts, they kept them at the price they had been before the COVID crisis. But then others were reselling those masks and people were willing to pay higher prices. And there was some criticism of 3M, and 3M understandably said, hey, it's not us, these other people are reselling it. So what they did was actually started filing several civil lawsuits on IP and trademark grounds against these unauthorized resellers who are attempting to resell their products at increased prices of more than 500%. And they're doing that to protect their brand. So even a company that's not intending to price gouge or be a profiteer is now sometimes facing these difficult situations where others are passing on their product at these gouge price, and it causes reputational harm. So I'm sure I'm watching every day these developments. I checked this morning to make sure there wasn't new cases I wasn't reporting on. And that makes it difficult to advise clients, and it makes it difficult for the clients to follow this closely when they're making strategic pricing decisions based on costs that are variable every day during the crisis. So that's the scoop from the US.
Okay, thanks, Anne. Very good presentation. I like it very much about this last topic that you did. And actually in Brazil, we have a long history of hoarding and price gouging, especially since we have a complicated history of macroeconomic policy, high inflation rates like 20 something years ago. So people here kind of developed a technology to, hoard products or do some plays with prices and so forth, to the point where antitrust here, it's so historically connected with price gouging that we have a statute in our federal constitution in 1988 that it's specifically directed through price gouging. So we call arbitrary profits, but it's the same idea. And I know that Carlos Ragazzo has some very interesting topics about this. We used to discuss this when he was first commissioner, then General-Superintendent. I will let him speak for the situation in Brazil. I'm sure he will have very interesting topics to raise with us. Ragazzo, please, it's your time.
And just a remark, so you know, Ragazzo has evolved from an antitrust lawyer into an antitrust economist. So we're really hopeful that he will have all the answers.
He has a very good nerd, antitrust nerd inside him, and
well, with that kind of presentation, what sort of thanks people are expecting from me? Well, then, thank you, I guess, for the introduction. And well, I have thought about this abusive pricing and price gouging for quite a while. We've been, into those discussions for many years. And I believe that one of the first times that we discussed this, you weren't even around, both of you, Victor and Eduardo, because most of these discussions were related to drugs, medication issues. They were actually, in the very beginning of the antitrust law in Brazil, the second and the previous antitrust law rather than this one. None of these cases were convicted. I don't remember a case being convicted for abusive pricing alone in Brazil in my term. I don't think there exists anyone like that. But there are a few things that are, interesting to discuss. And I'm trying to do this today with you. First of all, I think that the best way to look at what's happening is to go to the consumer protection agencies. I was looking into São Paulo, which is the biggest city in Brazil, and to see what was going on. And I found some very interesting things over there. First, there's a lot of active monitoring. There's several establishments being inspected. To give you the numbers, there were over 3,000 establishments that were inspected in São Paulo. Especially we're talking about supermarkets, pharmacies, LPG, liquefied gas, retail stores. 90% of those establishments were asked to provide invoices. 90%. So almost all of the establishments that were inspected by the local consumer protection agency received a request to provide invoices. Right after, and this is something very interesting, they were in position of heavy fines, not antitrust fines, consumer fines. So we're talking about 3 million reais. Most of it, like 2/3 of it, were pharmacies, and 1/3 of it was supermarkets. So you'd see, for instance, in this first stance, there's a lot of enforcement from the consumer protection agencies related to price gouging. And this is, from one standpoint, is doing ex officio, they're doing by themselves. And there's a lot of actual complaints coming in. There were not that many, in the beginning of the pandemic, for obvious reasons, but right after, you saw over 1,000% increase from March to May. And just to give you the rough numbers, this is roughly 5,000 complaints presented. Mostly related to food, to masks, to LPG, which is a common source of energy for cooking in Brazil, hand sanitizer, medication in general. So like the gist of it, it's not happening in the antitrust environment. And so the bulk of the complaints and the bulk of the action is now happening in the consumer protection agencies. I've seen, and Eduardo mentioned that there is a preliminary investigation on several health-related industries being carried out now at CADE. And they involve many sectors, hospitals, labs, pharmacies. There's retail involved into that. And up to this point, I think this is this is not expected to be otherwise. So there's a very early stage of this investigation. So anything that has happened so far is very preliminary. So up to this point, what I've saw is some just requests for invoices. Much like what happened in the Consumer Protection Agency investigations. Maybe, the calculations, the analysis will be different, but pretty much what we see, the level of information they are requiring is similar. So in Brazil, what we're seeing now is something preliminary and some sort of enforcement action, which is not based on very, let me try to find the right word for that, not, very thorough analysis. Basically, they're comparing the costs before, the prices and the costs before the pandemic and what happened afterwards. So I tried to do something different to bring something new to this panel. And I was looking into the benchmarking of some other BRICS country. It was easier to find something in South Africa. There are at least 9 cases already under investigation, already settled in South Africa for price gouging, or as they call it, for excessive prices. Mainly they're talking about the same kinds of products. We're talking about masks, we're talking about gloves, we're talking about hand sanitizers. And there are a few things to consider related to what's happening over there. First of all, you see, different sorts of margins being considered abusive. So you'd see, for instance, markups, the increases of 100% or 500% being considered, as the same. So they're being viewed as abusive. So there's not a clear distinction as to what kind of raise would be considered abusive. There's different sorts of rates going on at this time, and they're being considered abusive by the Competition Commission and the Tribunal. They have a very similar system to Brazil. They have a commission and they have an antitrust tribunal over there. So this is one. We don't have any sort of hint as to what is abusive, even though the cases are being considered to be anti-competitive. The second trend, which I think is very interesting, is that the commission in one specific case, has asked the tribunal to consider imposing treble damages, and has also suggested that should be applicable also to other cases involving future markets related to COVID. So there's not only do you see something related to, you don't know exactly what kind of rate, what kind of margin is going to be excessive, but also there's, some sort of a risk growing that can be very harshly punished, actually including treble damages, which is, for us in antitrust in Brazil is not something common or even possible at this stage at CADE. Also, a third trend is there's a lot of agreements. There's a lot of consent agreements being held already with the tribunal. So most of these companies, they're not deciding to challenge the commission investigation results. They're trying to look for the tribunal to get a settlement. And the results of those settlements have been, troublesome in my view. There's an obligation to cease and desist this excessively pricing mechanisms. And also there's a situation in which you'd see that the competition tribunal, they're trying to fix the prices, they fix the margins that the companies can charge. This is something that to a certain extent, this is complicated for me, because you're turning the competition agencies into a price regulatory agency, which usually is not a very good idea. And as a fourth trend, they're not only trying to revert to the point at the beginning of the pandemic, to the costs and to the prices charged, but also there is some sort of a trend in order to revert the prices that you charge in excess back to the consumers. So in order for you to be able to settle the case, not only do you have to have your prices fixed or your margins fixed, but also you have to return these excessive prices back to the consumers, which can be troublesome sometimes because there might be, thousands of people that bought your product in a given specific time in a market. So there are many things going on. Most of these cases, they were settled without admitting liability. So they chose not to move forward with the cases, just to, to have it ended. So you'd see, you don't have an idea what constitutes abusive. So answering the question from Eduardo, I don't see any good explanation coming from, anywhere in the world. There's a lot of actually, regulating of prices. There's a lot of regulation of prices coming on because the commissions, in order to resolve the issue, they're saying you can charge up until 10% higher than you used before, but not more than that. And some of these cases, they not only set the prices for now, but they set the prices for later, after the pandemic has ended. So one of these decisions, one of the settlements, there was an agreement upon the fact that the company had to, reduce the prices and maintain that reduction up until 6 months after the pandemic ended. So there's a lot of, odd, recommendations to the market related to that. So I was listening to Anne was saying that I don't know exactly what to say to my client. So I'm trying to get some sort of, some ideas and try to base on costs. And I think this is a wise decision to this point. But once you actually move into the competition agency, something very awkward can happen because they will actually be able to cap the prices and to maintain that cap after the pandemic. So I think for me, it's very hard to understand what's going on. And once you put a competition agency to decide that might not be a good idea. And why I think, from the economic standpoint, why this is a bad approach. I remember, after the Katrina hurricane, many, initiatives regarding legislation happened in the US. And I think some of them actually, came into force. And the economics actually said, the published article saying this might not be such a good idea because price is a signal. And so they convey, vital information to the market, and they actually make people enter into the market and offer these products that are, being charged with higher prices. So you just have to wait a little bit. So I'm not saying that you don't have to act in any regard, just, let the market as it goes, but maybe antitrust might not be the solution, because you have several, indirect effects regarding antitrust intervention in that specific part. And whenever you're trying to understand what is happening, you do have to understand also that consumer patterns, they change in crisis. We were discussing right before we got online that Brazilian consumers, they change whatever they bought. So first they were buying disinfectants, they were buying toilet paper. There were actually increases of over 500% in disinfectants and over 200% in toilet paper. But at the same time, they were buying less other stuff. They were buying less, for instance, pastries. They were buying less ice cream. They were buying less, fewer pet toys, for instance. And whenever you're trying to focus on retail stores, it's almost impossible for you to focus on a margin of a specific product. It's not wise to do that, because the fixed costs, they remain the same. And sometimes you just don't have, as much from the market as you used to have before, because there are a lot of changes in what you're buying. There's a lot of changes in the prices that are being practiced to people, and there's a lot of changes in what people buy. So you actually might be mixing with, in not an intelligent way, with the cash flow from a retail store. And I've been doing a lot of interviews regarding what's happening into the Brazilian economy. And I came to the conclusion that there are not many Brazilian retailers, even big retailers, that can have more than 6 months of cash flow. So what I've been seeing, just to be clear, is that the level of intervention, they seldom present some sort of thing that might be useful to the market. I think they are delaying some sort of discussion of a better solution towards what can happen to price gouging. And thirdly, it might hinder, retail stores, which are being, severely affected in Brazil. I'm not sure this is a good idea to have the some sort of competition enforcement over that. And I'm not even sure if it's the consumer agency should be the one doing that, rather than the competition. I think that the competition agency, perhaps they would have more, analysis, economic analysis, so they can, create less damage. So these are, some initial thoughts that I think that might be, interesting for us to discuss.
Thank you, Ragazzo. This was very good. I have a million questions, but we're having time issues here, so I won't be able to pose them right now. I'm going to pass the floor to Commissioner Paula. Thank you very much for being here. It's a pleasure and an honor to have a CADE commissioner speaking about this theme with us. I would guess that Commissioner Paula has the similar questions that we have, with the difference that she's going to have to trial them at some point. So she's in a tough spot. Paula, please feel free to comment as you wish.
Thank you. First of all, thank you, Eduardo. Thank you, Vito, for organizing the panel. I think it's great to have, a EU perspective, US perspective, be able to offer a little bit of Brazilian insight, and have Ragazzo, who you both mentioned, is not only an antitrust lawyer, but an economist, and I'm always happy to hear his views. So first of all, I'm not going to talk about any current investigations, obviously, and I'm going to try and keep this discussion more on an academic level and my personal views, given that there are several investigations that are now ongoing in the superintendents, and they could eventually reach the tribunal. So when we're talking about price gouging in Brazil, the first thing that comes to mind, and there are basically two questions that I have and that I would like to somehow answer during this conversation, which are, first of all, is this competition related? And secondly, should the government intervene? And if so, how? So let me start with the easy one, right? Is this a competition issue? And the answer is yes and no. It is a competition issue because it's explicitly written into our law. So abuse, or not abuse, but excessive profits, abuse of excessive profits, right? So something along the lines of arbitrary profits or excessive profiteering or something along those lines is a violation. But then, as Ragazzo already mentioned, there's never been a conviction. And there's rarely even been cases on this. There is one 2009 case involving Sindicato Vimpatinga versus White Martins, in which the issue wasn't, the antitrust test was discussed, but there wasn't a conviction or any actual decision about whether or not this test is the correct one. But so we see that, you know, it's a bit of, I think Tilman said this, I'll know it when I see it, but I haven't seen it yet. And so we kind of know that this exists, it may exist, but no one really knows what it looks like or what it's going to look like. And so I think that to begin thinking about this, first of all, we have to, you know, put this in an antitrust perspective and go away from economics for a minute and know that abusive pricing is a legal construct. So this isn't, from an economic point of view, this doesn't exist, right? So as a legal construct, we all, I think, agree that it should be analyzed under the rule of reason, and that there are basically two types, exclusionary and exploitative. Exclusionary is not, I think, what we were talking about in price gouging, but it would be more of the exploitative type, and it's only harmful to the extent that it arises from an infringement or an abuse of dominance. So high prices on their own should not be an infringement. It should only be an infringement if it causes an anti-competitive effect or if it results from this abusive profit, right? But that's where it gets complicated, because I can't really think of an example or have an idea of when a high price practiced by a dominant player would be a competitive infringement, because it's difficult to understand how this would actually affect competition. Or, you know, when we think about competition as the interaction of players within that field and you have a level playing field, are there barriers to entry? High prices on their own should not exclude competitors, should not create new barriers to entry. On the contrary, prices usually are a signal to you know, potential entrants that come on in, the water is good and there's profit to be had. So of course this idea that, you know, price is a signal and antitrust law sees it as generally a good thing and rejects the theory that, you know, high prices are bad for consumers even in emergencies. So when we talk about problems of natural disasters, what we're really talking about is we have a rapid shift in demand, we have a change in price elasticity, and supply sometimes isn't able to keep up with the shift in demand. So is there room for government intervention? I think there is room for government intervention. Should the antitrust authority be the one to do so? In my view, probably not. Of course, this would have to be case specific, and there might be a case out there where it is prudent for the antitrust authority to do so. Or there might be, for some jurisdictions, there might be a reason why the antitrust authority is doing this. And I think the example given by Ragazzo about South Africa is really interesting, especially because it seems that in South Africa, the reason why the antitrust authority is doing this is because there isn't really another authority that would have the legal mandate to do this immediately. So there might be a jurisdiction where if in lacking of a consumer protection agency, maybe the antitrust authority is the best position to do this. But I don't think that's the case in Brazil. I think we have a very strong consumer protection agency. We have a very good network of local consumer protection agencies that do a good job of this monitoring and price gouging and exploitative conduct. But, you know, going back to what should be done. So in my view, price caps are not the way to go. So price regulation, price caps, which are the traditional way of Brazilian legislation and Brazilian macroeconomic policy, is not necessarily going to respond to disasters, because when you have a disaster, like I said, what you need to do is not to decrease price, but you need to increase supply. So you need to help companies shift either their production or or accelerate their supply chain or reconstruct their global supply chain in order to get this product in, because essentially that's what we're talking about. That's why prices are high, is because you have a high demand for a product that is not in stock. So I think the hand sanitizers are a great example here in Brazil. Prices for hand sanitizers skyrocketed. And if the government's response had been, let's limit prices, what would not have happened is what we're seeing now, which is companies that produce personal care products, that produce home detergent, sanitizers, all these other, beverages, all of these other supply chains that could easily be diverted to producing hand sanitizer would not have done so. And this is what we've seen in Brazil, and the prices have come down because given, maybe a few days, a few weeks, supply has gotten to a position where there is more stock and these products are more readily available for consumers. I think the same thing is happening with masks. I remember a couple of weeks ago, and this is from my personal experience, I wanted to buy a pack of 50, discardable masks, and it cost me something around 400 reais. And this week I went to buy it, it cost me somewhere around 150 reais, and this is 3 weeks later. And but even when we talk about these high prices, I think another issue that isn't necessarily being talked about as much and isn't as intuitive for the layperson, but I think that we as enforcers need to talk about is the economic value of the product. So this same box of face masks under normal circumstances probably would have cost me about 40 reais, right? But I was willing to pay 400, and then I was willing to pay 150. So what does this mean? Does this mean that price is excessive? I don't know. It depends. What is the cost of the product? I mean, what is the cost of getting it from the factory to Brasilia to my house? What is the cost of the products that they need to make this mask? But more than that, what is the economic value of a face mask to me? So if consumers are willing to pay for this, and the price is somewhat linked to the economic value, which they should be, then how can we really talk about abusive profits? Tilman already talked about the United Brands decision, and since we don't have any Brazilian really case law about this, I think that's a good starting point, and it talks about what's the economic value relative to other goods. But ultimately, the problem with abusive pricing in a competition arena is that competition enforcers don't want to be price regulators. That's not what we were trained to do. That's not the most efficient use of resources. And it might not even have the best externalities from a public policy perspective for the market and for consumers. So we tend to avoid that, not only because we don't want to do it, but also because it's complicated. Structural remedies usually aren't effective. You need something that's going to be constantly monitored. It's very time-consuming. It's very consuming for agencies in general. So when we're talking about deep crises like the one that we're facing now, we need to remember, first of all, this is transitory. If we are to intervene, it has to be a very short-term response to a very short-term problem. Usually, if you let the market respond, or if you give the market condition to respond, such as bailing out firms or making sure that you don't have a general requests for bankruptcy, the market will somehow, rearrange itself, as long as you don't have, and I think these are important conditions, and I'm taking this from the Evans and Padilla test, which is basically the prices charged by the firm widely exceed its average total costs, right? The dominant firm enjoys a near monopoly position in the market, and there are no insurmountable barriers to entry, and there are insurmountable barriers to entry. And finally, there is a risk that prices may prevent the emergence of new goods and services in adjacent markets. I think this is the issue where antitrust, if it is to intervene, if it is to really enforce abusive pricing, then this is when we should enter. When the risk that these prices will somehow avoid the emergence of new goods and services in adjacent markets. Therefore, it would be one type of abusive pricing where you would have, you would be disturbing the level playing field of competition. So let me just see if I can, see if I said everything that I wanted to say. Oh, there's one more issue, and that's just related to dominance. When we're talking about abusive pricing, we're talking about abusive dominance. And dominance is unilateral ability to influence prices. But when we're talking about very short-term and deep crisis, small players that normally would not have dominance suddenly have dominance and market power. Why? Because you have geographical restrictions, many people are on lockdown, that's the only available source, and suddenly the small pharmacy next to your house is a dominant player because that's the only place that you can get your medication or whatnot. So there is, enforcers have to be careful and have to be wary of how to approach this dominance. I know that Jenny and Mata have both talked about this, but one thing that I haven't seen, and I would love to be interested, and I would be very interested in hearing from someone who does know about this, is what are other jurisdictions doing? Is dominance something that is pre-crisis, or is dominance also going to be ascertained post-crisis or during the crisis? Because any type of antitrust intervention is going to last longer than a crisis. So is this very short-term, unintentional excessive pricing by your local pharmacist, is this really an antitrust concern? And is this something that we really want to dedicate public resources and very limited public resources to pursuing? So I think I just want to conclude saying that I have a couple of general takeaways. First of all, determining the level at which a price is excessive or unfair is difficult, uncertain, nearly impossible, I would say. Competition authorities' efforts to prevent exploitative schemes are anecdotal at best, so there's very little that we can go on right now. High prices usually self-correct, and if they're not self-correcting, price caps are not necessarily the best option. Maybe the way to go about it is in stimulating supply. There's a wide consensus that controlling high prices imposed by dominant firms in dynamic industries is absolutely terrible, and it has very, very negative externalities. So we need to be very cautious of this in industries where investment and innovation are critically important, such as medicine and medical engineering, which are at the epicenter of this sanitary crisis. And finally, enforcement actions against exploitative conduct, in my view, should be taken only as a last resort and only when there is no other authority that could efficiently deal with this problem. So those would be my comments. Thank you for listening, and thank you again for the invitation.
Thank you, Commissioner Paula. Unfortunately, we have sort of run out of time. I think we could discuss several of these issues. I very much liked Paula's presentation. I think she said a lot about what should not be done and some of the possible paths. Of course, as any of us, she's not able to answer exactly what we should do and what authorities should do. There's still a lot of open questions. Since we don't have much time, I'm just going to comment on what to me is the main question, and it has lots of consequences. So the main question that none of us was able to answer, because as Paula said, maybe this is impossible to answer, is what is an appropriate price? What is an appropriate profit margin? What is a profiteer? What is an opportunistic behavior? And as long as we don't have the answer for that, and it seems to me that we don't, everything authorities do and everything we do will be based on the I know it when I see it approach. As a lawyer, I am very, very scared of this approach because it has several issues of due process, of presumption of innocence, of, it even has an arbitrary totalitarian connotation to it that worries me from several points of view. Having said that, of course, we're living in a health crisis, and all of us would love for health goods and other goods to get to the people that it needs to get. And of course, this is an issue. I worry as a citizen, though, because it seems to me that several authorities, and just to make clear, I don't think CADE is one of these authorities. I think CADE is handling all this in a very responsible manner. But I know as a fact that several authorities are not stopping to think that if you get this wrong, if you go on with wrong measures, you can actually make things much, much worse. If you obligate companies, either by regulating prices, either by fining them, if you make companies come up with a price that is lower than their cost, they will just stop supply. This is evident. This is obvious. It worries me that some authorities, this is not an issue just in Brazil, everywhere, might be coming up with populist measures that are not going to go anywhere. And it worries me even more if we are concentrating resources in this type of investigations instead of concentrating into tackling the real problem, which is we have a problem of supply and we have a problem of demand. And maybe we should be dealing with this. But of course, this doesn't mean that the proper authorities shouldn't be looking into all this, but we still have an issue of how to do so. I think it's important that they know that the wrong measures can do much more damage. I would have more questions, and I'd love to open up for everybody to ask questions as well, but I think we've taken much more of the time of the panelists than we could ask for. So I'll just ask if any of you has any last comments that you wish to make. Please don't feel obligated to do so, but if you want to, I think we still can take maybe 3 minutes or so.
Just one quick remark. Paula was asking whether there's any jurisdiction in the world in which this discussion of temporary market power has a reason. That has a reason in South Africa. A specific decision related to the pharmacies market, in which the restriction of movement by consumers was considered something to be taken into account. I can send it over to you if you want me to.
1976 ABG oil case in Europe as well, although it's not particularly well explained there. Maybe just a quick comment. I mean, the difficulty to grasp all of this is because this is another area of the law where we're seeing a convergence between concepts of antitrust and consumer protection, right? So it doesn't feel right. We know we need to do something. Not all consumer protection agencies have the right enforcement powers to tackle this from a consumer protection perspective. I think if you think about the hierarchy of who should be doing what, I do think price regulation should be something that the government does, right? The government, elected officials, they need to decide if I think a price is too unfair for my citizens, something that Paula said, you know, we're not talking about certain goods are not coming to the market, it's just exploiting consumers, then, you know, they need to take charge of that. I remember very well the discussion about EU consumer protection law, and there was a very different understanding between EU member states of what the average consumer is, yeah? And what a responsible, reasonable, self-determined decision can be, and how much do you need to protect the poor consumer, or would you, give them some more independence? So that's really something that a national government probably should decide. And as we heard, price caps can have unintended consequences. Take, for example, a company that is not dominant, but has a higher quality, top tier offering. Maybe the dominant company has a lower price. If you now force the dominant company to lower the price even further, you're making investments into higher quality and R&D and so on for someone else more difficult. And the German Facebook case is a good example. they found a data privacy violation. They thought the data privacy agencies don't have enough enforcement powers, and they went after it. And the court stopped them because this is something the data privacy agencies should be doing. And so I think your price regulation, either you come up with regulation like interchanges, like roaming, or what have you, or you more or less leave it alone. The only thing you can get to somewhat a more reasonable, more understandable approach from the antitrust perspective, if you want to say exploitative abuse is something that the agencies should cover anyway, would really be this comparison approach where you say, I'm looking at another market where there's no dominance, but it's still the criteria of supply and demand are somewhat similar. And then, the price needs to be massively above that. And there's some German case law that looks at how big is the price difference. Then I put some surcharges on it because it's never 100% comparable. And then you may have a way of doing it. But just to pronounce as an agency to say this is an appropriate profit margin, that just can't work.
Eduardo, if I may just make a really
Please,
brief comment.
Paula.
I just wanted to resonate a little bit about what Eduardo said about judicial certainty and populism. And I think that is a risk that we're going through right now in Brazil. This is very new, and we have a history that is paved with, well-intentioned price regulation with disastrous effects in Brazil. We've seen that over the last few decades. And I completely agree with Tilman that if price regulation due to unfairness is going to be contemplated, then let's let elected officials do this rather than competition officials.
Well, thank you, Paula, for your comments. Fortunately, we are running out of time, as Eduardo said. So on behalf of IDP, I thank you for your time. We know how valuable it is for you to have 2 hours of your day to discuss with us. But it was an outstanding seminar about a hot and difficult topic. And I'm really glad that you accepted and participated with this with us. We will put together the 2 videos, create a link for YouTube for more people to be able to see our discussion, and we'll send you by email. It will be broadcasted at 5 p.m. Brazil time, which I guess is 3 p.m. EST and 8 p.m. London time. And with this, I renew my thanks for you on behalf of me and Eduardo and the IDP. Thank you very much for your patience with us. And with this, I will declare this meeting ended. Thank you very much, people. Say goodbye, and I hope you see each other again. Thank you.
Thank you.
Thank you all.
Bye-bye.
Bye,
Bye-bye.
thank you.